What is the difference between a first-party special needs trust and a third-party special needs trust? Very small change in the name, very big and important difference between these two types of trusts. All right, so let's get into it. I'm Jason Neufeld. I'm an elder law attorney with Elder Needs Law, and we serve Medicaid planning, estate planning, and probate clients all throughout the state of Florida. If you're asking the question, what's the difference between a first-party special needs trust and a third-party special needs trust, it's probably because you're interested in Medicaid planning to get help paying for long-term care expenses, or you want to maintain eligibility for SSI. These are needs-based government programs that only allow you to have a certain amount in income and assets. Let's get into it. I want you to think of a first part. If you're my client and you may be thinking of somebody, you may be watching this video on behalf of someone else, but pretend for a second that you're my client and you're interested in obtaining or keeping these needs-based government benefits such as Medicaid. If you're my client, you're the first party. And if you're anyone else in this world, we refer to them as a third party, okay? That's just an important basic distinction. So in a first party special needs trust, you are taking your money and you are setting it aside in a special needs trust where it will not count against you when determining whether or not you're eligible for needs-based government programs such as Medicaid. Now, if you are under the age of 65 in Florida, you can choose anybody you want to be the trustee of that trust. It just can't be you, and it can't be your spouse. It can be a child, it can be a mother, it can be anybody you want. Sometimes you hire a professional, that's okay too. It just cannot be the benefits recipient themselves, right? They're not allowed to have control of these assets. But anything in this trust that's managed by someone else can be used for anything the Medicaid beneficiary needs or wants. If you have SSI, not Social Security Retirement, but SSI, which is another needs-based government program, there are several restrictions on how those funds can be spent, but not many, and for the purposes of, we're going to stay away from that for the purposes of this video. But the point being, it can pay for almost anything you need or want. And if you're just on Medicaid in Florida, not on SSI, the sky's the limit. It can pay for entertainment expenses, it can pay for mortgage payments or rent payments or additional bills that might be due in the assisted living facility or extra home care, it pays for your vacation, whatever you want. The primary drawbacks to a first-party special needs trust are in Florida, when we're talking about Medicaid, you have to be under the age of 65 in order to have someone be the trustee. If you are over the age of 65 in Florida, you have to use a professional nonprofit organization. Sometimes you want that anyway because you don't have anyone in your life. You might not have anyone in your life that you trust to be the trustee of this very important component of your life. So that's one item you need to be aware of. The second, and usually the most disturbing aspect of a first-party special needs trust is after the Medicaid recipient passes away, the trustee, whether it's a professional trustee or whether it's someone you choose to be the trustee of your special needs trust, has an obligation to notify Medicaid. Even if you had Medicaid in different states, that you have to notify the Medicaid agency in every state in which you've received benefits, but let's just say we're in Florida. Medicaid will then send a bill. They'll go, here is how much we have spent on the beneficiary's care and services while they've been on our program. And out of funds that remain in the trust, Medicaid has to get paid back first, dollar for dollar. And only if there is money left over in a first-party special needs trust does the family of the Medicaid beneficiary have a chance of getting $1. Okay? So whether the family is entitled to any money after a Medicaid beneficiary passes away is a function of how much money is left over versus how much money Medicaid has spent, and whether or not there's a difference in those numbers. So that's in a nutshell a first-party special needs trust. But if you're under the age of 65, while you are alive, that money can be invested and grow, and it can really improve the quality of a Medicaid beneficiary's life. And even if you're over the age of 65 and using one of these nonprofit agencies, they can also invest the money if you so choose. Let's compare and contrast that with a third-party special needs trust. Remember, first party is you, third party, anybody else. A third-party special needs trust is comprised of funds that didn't belong to you. They belong to somebody else. Very typically and most commonly, this is a parent or a grandparent setting up a special needs trust for the benefit of their special needs child. But sometimes, I just had a client come in a couple weeks ago who wanted to set up a third-party special needs trust for a very close friend, a childhood friend. They've been friends for 60-something years, and he wanted to set aside funds to not jeopardize that individual's needs-based public benefits, and that's perfectly fine. The difference is there's no age restriction on who can be the trustee. You can name a professional, you can name another individual to be the trustee of a third-party special needs trust. And again, the big benefit is after the Medicaid beneficiary passes away, because it was never the Medicaid beneficiary's money to begin with, there is no Medicaid payback obligation. Okay? So if the money did not originate with the Medicaid beneficiary, if the money originated from a friend or a relative, it's now third-party money, and the funds in that special needs trust will not jeopardize their access to these benefits, and it can pay for anything, nearly anything, that Medicaid doesn't already cover. Again, greatly enhancing, hopefully, the quality of the needs-based the Medicaid beneficiary's life. And after they pass away, then it goes wherever you want. So that's first-party special needs trust and a third-party special needs trust in a nutshell. Some common scenarios where people get confused is, let's say you're my client, you're a needs-based beneficiary, you are coming into an inheritance. Well, if it goes to you, that's first-party money, that's your money. So that's what we really want to be sure that if you're a needs-based, if you're a special needs person who's on needs-based government benefits, your family really needs to see their estate planning attorney. And if they're anywhere in Florida, you feel free to call upon us. But if they're in another state, then we're happy to refer you to an attorney in any other state in the union. They need to set up their estate planning so that the special needs individual never inherits money directly. They want a third-party special needs trust to be the receptacle of that money, because then they don't have to pay it back. But if it goes to the individual first, if it's ever at any point in time sitting in their bank account, now it's their money, and now you have to use a first-party special needs trust. Very similarly, a personal injury settlement, right? There's no way to conceive of that as being anything other than your money. That's where, among other Medicaid planning or preservation techniques we have available to us, we may be talking about a first-party special needs trust. We won't be talking about necessarily a third-party special needs trust, but just also be aware that we have more than special needs trusts in our toolbox, right? These are not the only options, but if we're discussing first-party versus third-party special needs trusts, these are the big differences you need to be aware of. So there's more to it than that. There's some tax differences on how the different trusts are set up, and certainly many more nuances than we have time to get into in this short video, but I hope this has at least given you an entree as to the differences between these two very important documents. And if you're anywhere in Florida, or if you have a loved one anywhere in Florida and you're interested in talking more about this, please set up a consultation. Our firm serves the entire state of Florida, and I look forward to working with you. Thank you very much.